Our next case is People versus McKewen. A bit of a traffic jam. Good morning. This is a calendar case, 15 minutes per side. You have 2 minutes of a free fire zone, which you may waive, and you may reserve time for rebuttal, but we ask that you try to keep track of that yourself. And you may begin when you're ready.
Thank you very much, Your Honor. Good morning, Assistant Attorney General Kayla Crino, appearing on behalf of the people. Along with me today is the Solicitor General for the State of Michigan, Ann Sherman, who is seated at council table. May it please the court. If possible, I'll reserve 2 minutes for rebuttal today. I must first address that much has changed since we first filed our application in 2018. Most importantly, we understand that this court's opinion in Wafer has substantially weakened the argument that the conflicting intent provisions, like those present in the statutes we're dealing with here today, do not evince a legislative intent to prohibit multiple punishments. We understand that this court did not accept that argument in Wafer, and we understand that correspondingly, based on Wafer, it's unlikely to accept a similar argument here today, but that does not mean that McKewen is entitled to relief. As to the question of double jeopardy posed by this court, convictions for assault, GBH, and felonious assault do not violate double jeopardy protections. The legislature clearly conveyed its intent to permit multiple punishments when assault GBH is involved by amending the assault GBH statute in 2013 to include a provision that states a defendant may be charged with, convicted of, or punished for any other violation of law arising out of the same conduct as the violation of this section. Felonious assault was in existence at the time of this amendment, and of course this court had already decided Strother, finding that felonious assault and assault GBH do not violate double jeopardy. Had the legislature wanted to create some type of exception for felonious assault or anything else, they certainly could have. And Wafer ultimately supports the conclusion that convictions under these statutes do not violate double jeopardy. Wafer, of course, dealt with involuntary manslaughter and second-degree murder. These statutes from Wafer do not contain a provision authorizing multiple punishments. And addressing that point, this court wrote in Wafer, absent other textual indications to the contrary, and there are none here, it is hard to imagine a clearer sign that the legislature did not intend to authorize multiple punishments for these crimes. Well, here we have those exact textual indications to the contrary in the form of the legislature stating that multiple charges, convictions, and sentences are permitted when assault GBH is involved. And with that, I'm happy to take the court's questions at any time. You might ask next, doesn't the conflict between assault GBH's intent element and felonious assaults without intent provision, when paired with the assault GBH statute's provision that multiple charges, convictions, and sentences are permitted, doesn't that create ambiguity as to the legislature's intent? Well, as a result, in Davis 2, after remand from this court, paired with this court's decision in Wafer, seems to indicate that it does not, and that instead, assault GBH's clear statement of legislative intent to allow multiple punishments is what controls. It is that textual indication to the contrary that was absent when this court analyzed the statutes involved in Wafer. As the Court of Appeals stated in Davis 2, the only way to find otherwise would be to disregard or completely rewrite MCL 750.843. But if you disagree with me on that point and believe that MCL 750.843 is not a clear statement of the legislature's intent to authorize multiple punishments, well, then the next step is the application of the abstract elements test. and an inquiry into whether a conviction of one charge necessarily requires a conviction for the other. And of course, this court has already held that that is not the case in Strother. Nothing has changed since Strother. That's exactly how it is at present. Now, turning to the mutually exclusive verdicts or judgment argument, there are three things that are noteworthy, and I do want to address that today, and I'll explain why. First, this is the argument in this case that the Court of Appeals actually granted relief on, and this is the decision that we're here asking this court to reverse, so that's why I want to address that. Second, when the Court of Appeals granted relief on this issue, it did so in reliance on the analysis from its own 2017 opinion in Davis, and that's exactly the reasoning that this court ultimately rejected in its own 2019 order in Davis, where this court explained that regardless of whether the mutually exclusive verdicts doctrine even exists in Michigan, it isn't what was present in Davis. And the same thing is true here, because in this case, the jury was never instructed regarding that negative intent provision that's present in felonious assault. Third, I acknowledge that McKewen's brief in this court seems to concede that the Court of Appeals erroneously granted relief on this issue. Well, we certainly agree with that and are asking the court to reverse that component of the Court of Appeals' decision. Because the jury was properly instructed here, this just isn't an issue of a mutually exclusive verdict. Now, I also want to address mutually exclusive judgments. So reframing the issue into one of mutually exclusive judgments doesn't change the analysis here, and that was something that we saw in the Court of Appeals dissent in Davis too, after remand from this court. The trial court's judgment after a jury's verdict simply memorializes the defendant's convictions based on the jury's findings. So calling it a mutually exclusive verdict, giving it a different name, doesn't mean that the defendant is entitled to relief, because that order entered by the court simply memorializes what the jury ultimately found. It does not matter that the judge knows about the absence of malice provision. If the jury did not reach a mutually exclusive verdict, then the judgment memorializing that is not mutually exclusive either. So for all of these reasons, we're ultimately asking that this court reverse the Court of Appeals holding that the convictions were mutually exclusive, and also find that the convictions did not violate double jeopardy. Does the court have any questions for me on any of the arguments?
I'm curious if whether or not you think, even I recognize that the assault with intent to commit great bodily harm statute states that there is no prohibition for a person to be charged with another violation arising out of the same conduct. Is it relevant or dispositive, or how does it fit in the fact that the felonious assault statute does not contain a similar sort of legislative intent that another crime can be charged as well? Do both, to give sort of effect to the legislative intent that says that both of these charges, or both, somebody can be convicted of both, do both statutes need to have that clear sort of expression that that's what the legislature intended?
They don't. Ultimately, what you have to look at is the convictions that you're dealing with in any individual case. And of course, here we're dealing with assault, GBH, and felonious assault. So, the provision contained in the assault GBH statute, couldn't be more clear. Any other violation of law. And so, so no, to answer your question, it's really just exactly the same situation that we had in Davis. Aggravated domestic assault doesn't include that same provision that we have in the assault GBH statute, and at least as it stands today, convictions for those two do not violate double jeopardy, and assault, aggravated domestic assault does not include that same provision. So no, you have to, of course, look at the statutes that you're dealing with, and I think that the first question is, is there a provision like that, like a clear statement of the legislature's intent? And because we have that, what we can
well, the clear
from
statement would be that both have. They say these two, in fact, can be, like there's no prohibition, and in fact the legislature intends that both of them can be charged and somebody can be convicted. The sort of other end of the spectrum is where neither does. how does the lack of it in the felonious assault statute, for lack of a better sort of phrasing, does that inform that this is what the legislature intended, that these two crimes can in fact be supported in one conviction?
Well, I think what we can conclude is that what the legislature intended is that when assault with intent to do great bodily harm is involved, the defendant can be charged with any other violation of law. So it doesn't say the defendant can be charged with any other violation of law, but only if the other violation of law that we're talking about has a provision that mirrors this one present in the assault GBH statute. So what we can conclude in terms of legislative intent from the two statutes that we're dealing with today is that when assault GBH is involved, the legislature intended that the defendant may be charged with, convicted of, or sentenced for any other violation of law, and that's without respect to the fact that that provision is absent in felonious assault. Are there any other questions?
I don't see any right now.
All right, very good. I'll reserve the remainder of my time for rebuttal. Thank you very much.
Good morning, Your Honors. Matt Monahan, Assistant Defender. May it please this Court. I'd like to begin with 84 subsection 3, given the state's focus on it a moment ago. The state's read of 84.3 begins and ends with the first clause, any other violation of law. But the statute doesn't end there. The statute goes on to say, arising out of the same conduct, and then refers back to this section. This section speaks to the conduct covered by 84, which is an assault by strangulation or an assault with intent to commit great bodily harm. What the legislature has done there is do exactly what this court's multiple punishment strand cases require. Give a clear statement of intent with respect to multiple punishments. Yes, multiple punishments are permitted in some instances. But the instances where they're permitted is when the conduct stems or arises from an assault with intent to commit great bodily harm. It's the shared intent that gives meaning to same conduct. What the state wants is to get same conduct into a much broader framework where any violation of law, period, permits multiple punishments. But the legislature didn't say that. They gave a far more specific authorization to the courts, and that specific authorization goes to shared intent. An assault without intent cannot arise from an assault with intent. In this instance, where you have one act and you get two convictions, the only way to give effect to every bit of the plain language in 84.3 and in 82 is to treat same conduct as the shared intent. And that means Mr. McKewen can only be convicted and only be punished for one assault. There's a broader purpose here, and that's clarity for trial courts, because the multiple punishments provision of double jeopardy is not meant to limit the legislature. It's also really not meant to limit the prosecutor's charging decision. It's meant to give trial courts clear guidance about when and how to protect and promote double jeopardy rights. The clarity from the legislature in Section 84 is essentially, it's the legislature actualizing this court's multiple punishments test. When this court says in Smith, then reaffirms in Miller and again in Wafer, that it's about plain text, because plain text is the plainest statement of intent. What Section 84.3 does is tell the trial courts where to look. I go to the plain text, and I look for the same conduct.
But aren't you, I'm still sort of digesting what you were saying earlier, that aren't you categorizing conduct as used in 84.3 to say conduct with the same intent?
Absolutely, yes. That's what the legislature's...
But the legislature doesn't say. Like, conduct is I think the plain reading of it is the act, right? The stabbing. Whether it's with a particular intent or another particular intent. That's not what it says. It says the conduct. So aren't you sort of reading into the use of the word conduct in sub 3 a little? You're reading something into it. You're reading conduct with the same intent.
No, Your Honor, because the legislature has said arising, same conduct, and then this section, they've put some specific limits on conduct. The other way to get at this is context. If conduct just means the assaultive act, then what 84.3 is doing is sapping any force to 82 when 82 says without intending great bodily harm. And that language in 82 is important because when you step back, the context here and the assaultive statutes in the penal code gradate punishment based on state of mind. So this language in the statutes that speaks to the different intents. There's without intending in felonious assault. There's with intent to do great bodily harm in AGBH, with intent to murder in AWIM. Those different pieces of the statute speak to different punishments, and 84.3 has to respect that context. So conduct has to mean, especially when it's paired with same conduct and this section speaks only to an assault with a specific intent.
What do we do, though, the statute refers specifically to any other violation of the law, pairing that with arising out of the same conduct? Does that mean it's broader than what you're saying?
It is a authorization to any other violation of law, is definitely a permission to permit multiple punishments, but it's not that any other doesn't broaden out the meaning of same conduct. And if any other violation of law would collect within it a violation of 82, then you're reading both the last clause of 3 out, arising out of the same conduct, and you're reading without intending to commit great bodily harm out of 82. All of these statutes have to piece together, especially in light of Doss, that says this without intending language, this negative element, it's not read to the jury. Just as in Wafer, without malice is not read to the jury. So the legislature's put that language in there for a reason. And the reason is punishment. Without intending to commit great bodily harm is why you have a 4-year felony for felonious assault. With intent to commit great bodily harm is why you have a 10-year felony for AGBH. And going, Justice Kavanaugh, to your question, well, shouldn't the legislature have added this subsection 3 to 82? Wouldn't that have really given us an indicator? It would, but the legislature is not, the legislature has flexibility under this multiple punishment strand. When the legislature has decided not to add subsection 3 of 84 to 82, really what they're saying is that without intending language in 82 does matter, because that language is doing work when you've got convictions for felonious assault and assault with intent to commit great bodily harm. You don't need the subsection 3 in this case to be in 82 because you have the conflicting intent provisions, and that's not the same conduct in the context of the assaults, or excuse me, the assaultive crimes within the penal code. I'd like to go to Strother and Strickland for a moment, which are the two cases. Strother is the order out of this court that the Court of Appeals treated as dispositive in its opinion below, and this dovetails with the mutually exclusive verdicts / judgments argument. Strother doesn't have any reliance interest here for 2 reasons. One, and this goes to this court's precedent, beginning with Smith, going into Miller and into Wafer, this court has been clear that multiple punishments turns on legislative intent, and the best indicator of legislative intent since the 80s decisions out of the Supreme Court, Albernaz and Garrett come to mind, the best indicator is text. Where you have a clear textual indication, and you have that here in 2 places with the dueling intent language and the arising out of the same conduct language in section 3, you don't get to the elements because Blockberger is just a tool of statutory construction. It's not a constitutional imperative. That opinion itself never mentions double jeopardy or the Fifth Amendment. It's just an attempt to construct a statute. Strother misses the mark in failing to apply step one of this court's double jeopardy precedent and jumps right to the elements test. The other problem with Strother is that it misreads the plain language. If you give Strother its full meaning, then Section 82, without intending to commit great bodily harm, has absolutely no force in this case. It's out of the statute, and it's out of the statute in any other application of AGBH and felonious assault. And this court we can't read statutes so that parts of them just have no effect. Not only because it upsets 82, but it upsets the broader context generally of how the legislature's decided to punish assaultive conduct.
Well, it's only reading it out if these two are charged together.
That's right. In this narrative, yes.
Felonious assault can be charged.
That's right.
And that legislative intent can be effectuated.
That's right.
Okay.
In this case, when you have one act, two convictions, with and without, you have to read without intending to commit great bodily harm out of the statute. But even in that narrow sense, that you have to read the language out speaks to the problem with the state's interpretation, because that language goes to punishment. It also, in the context of an assault, goes to same conduct. So you put that together and you apply step one of the Wafer-Miller-Smith test, and what the legislature's done here is speak with clarity, a clarity that's necessary for trial courts when one act generates two convictions, and the convictions are for with and without intending to commit great bodily harm. Double jeopardy's prohibition on multiple punishments prohibits a trial court from entering two convictions and imposing cumulative punishment. Unless there are further questions, we'd ask that you vacate the lesser conviction and remand for resentencing.
Thank you very much.
Thank you.
So I just want to briefly interpret the defense's proposed interpretation of MCL 750.843. That what it means is that it refers to assault by strangulation, or in the alternative, assaults that involve an intent to do great bodily harm. There are really three significant problems with that argument. First of all, that isn't what MCL 750.843 says. It just plainly is not what it says, and no one is asking this court to ignore any component of that provision. We want the court to consider it in its entirety. So what it really says is this section does not prohibit a person from being charged with, convicted of, or punished for any other violation of law arising out of the same conduct as the violation of this section.
So let me stop you there. If the statute said doesn't prohibit a person from being charged with yada yada, any other violation of law arising out of the same conduct.
There are a lot of statutes that substitute transaction for conduct, oddly enough, given the first case that this court heard.
But I mean, I think the argument is it doesn't stop at arising out of the same conduct. It says arising out of the same conduct as the violation of this statute, which would naturally sort of bring you back to A and B. One A and B.
Well, the problem with that is that if that's what the legislature really intended here, it would have said, you know, any other violation of law, but not violations of felonious assault, or not things other than assault GBH, or not things other than assault GBH, or things that have the exact same intent as required for assault GBH. And it doesn't say any of those things. It states that any other violation of law. So it would have been really easy if what the legislature actually intended here was to have a really narrow provision that only applies to assault strangulation, or assaults that have the same type of intent required for assault GBH. They really could have said that, and a great time to do that would have been in 2013 when they added this provision to the statute. So that's the first major problem with that interpretation. The second, though, I certainly acknowledge that this isn't a case that's binding on this court, but People versus Barber, a published case from the Court of Appeals, after remand from this court in 2020, held that convictions for assault GBH and assault by strangulation that arise out of the same single assault do violate double jeopardy. So half of what the defendant is proposing with their interpretation, at least as the law currently stands in Michigan, half of what he's already proposing that this court should say that Section 3 means, it doesn't fly. It already violates double jeopardy to interpret it in the manner that the defendant suggests. So that's just, simply improper. Third, the felonious assault statute, as I mentioned earlier, it isn't the only place where we see this type of language. We also see it in a lot of other criminal statutes, including the witness intimidation statute, using a computer to commit a crime.
In those statutes, you see the conflicting language of with intent and without intent?
No, what you see, there's certainly pairings that could occur where there's that type of conflicting intent, but what I'm actually talking about is sections that mirror Section 3 from the assault GBH statute.
Right, but we can't look at that in isolation. I mean, just because that language is there in those other statutes, do you have two statutes that could be read as conflicting with the without intent and with intent?
I understand, and I agree with the court. I completely understand where you're coming from on that. But what I'm specifically addressing is the interpretation that the defense is proposing for Section 3. We see that type of language in a lot of other criminal statutes. I've read this court's...
and I know this is sort of maybe more vibes than law, but doesn't it sort of make sense that the legislature would say it's okay to tack on other crimes that are sort of in this same category of the same intent? It's sort of illogical to think we are authorizing additional punishment for a crime that has this specific intent and for the complete opposite type of intent, like a complete opposite type of, doesn't it sort of make sense, that argument? And I get we can parse the words to say whether or not they plainly sort of do that, and I understand your argument and his, but like 30,000 foot level, doesn't it sort of make sense that you're like, you can treat other similar type of crime, similar type of intent? Doesn't that make more sense than saying you can take, apples and you can take oranges and you can charge them both?
I guess what I'm hearing underlying that question is sort of, I'm going to simplify it, and if I'm wrong in simplifying in this manner, please let me know. But it sounds like the court is asking, is this fair? Almost, and that's something that I've thought about, and ultimately what the legislature did with the statutory framework that we're dealing with in this case is that they punished two very distinct wrongs that are both very serious. One with the assault.
Is it possible that what the legislature did here is give two different options for charging, where you have a situation, a case where you can prove intent, and one where you cannot prove intent, and so they're giving the prosecution both options with the thought that they're going to charge or prove one or the other and not both?
If what we had was a situation that mirrored the statutes in Wafer, I would agree with the court entirely, but MCL 750.823 makes it different here, just like it was different when we were talking about assault with an aggravated domestic assault. So Section 3 changes everything. If we didn't have Section 3, I would completely agree with the court, and I would say that Wafer ends this, but we have Section 3, and
Section 3 could be talking about other statutory sections, right?
I'm sorry?
It doesn't preclude other sections where you have the intent piece isn't in question, where where the crimes line up where there's no intent. Mm-hmm. You don't need to prove intent versus where you do. And it's not like it's in there and it can't apply anywhere because of the argument that the defense is making.
Ultimately, what we have here.
I guess what I'm asking you is, are you giving too much credibility to 3 when it can still be applied, but just not when there's these two sections that can or could be read in conflict?
Well, I understand that within the defense's proposed interpretation for Section 3, it could still be applied. The problem with the defense's interpretation is that's not what Section 3 says. Like, we're adding words to it, we're adding exemptions that do not exist there. You know, what it says is that the defendant can be charged with any other violation of law that's arising out of that same conduct. And so to
But it
add
doesn't say that.
something-
It doesn't say arising out of the same conduct. It's arising out of the same conduct as the violation of this section. And I get it. I would think we're beating a dead horse at this point. But I mean, I guess that's it. Like, yes, normally you could say, look it, the legislature knows how to say, other than felonious assault, other than crimes that have a negative intent element. Or, you know, I mean, they could have said it 100 different ways. Their contention is that they didn't stop with just saying out of the same conduct, as it's the same conduct as the violation of this section.
Yes, we completely agree with that, and that doesn't harm that and the plain interpretation and plain meaning of that section. The same conduct refers to the assault that's being charged. When you pair the same conduct as the violation of this section, there's no other interpretation that you can make from that except the assault that's being charged underneath this statute. And so read in its entirety, what Section 3 tells us is that when assault GBH is involved, the defendant can be charged with any other violation of law as the same conduct as the violation of this section. So they're just, any other interpretation is adding words that are simply not present in that section. So, you know, ultimately, unless there are other questions, we'd ask that this court reverse the Court of Appeals decision that these convictions are mutually exclusive and find that these convictions do not violate double jeopardy.
Thank you both. The
Thank
case
you.
will be submitted.